To our second simultaneous panel of the day. Today is a panel entitled The Reach and Range of Judicial Review. And you wouldn't be wrong if you wondered if I put this panel together along with Sonia and Ben, just so that we could invite the three panelists here today. So in Concase's 26-year history, it's never once stepped outside of its usual model, which is that we stick to the year's cases. But we've been reading with great interest and care the writings of these three colleagues here on the stage today, who've been writing really important work in incredibly pressing issues of constitutional politics. So the idea of the day was we were trying to think about constitutional political issues where there might be structural features of the Constitution or pieces of legislation that aim to limit how the court might hear cases or come to respond to constitutional issues. So in an ode to Bob Dylan, Subterranean Constitutional Blues. It's always slightly amiss to say something too sentimental about the speakers who are here. But can I just say that I really look up to each of them because I see them as unflinching and tireless in their willingness to take public-facing, steady, and morally clear positions on contentious legal issues and steadfastly working to offer depth, vista, and exceptional thoughtfulness in this endless season of political spin. So we have a practice of short introductions, and they all know I would like to go much longer. But I will simply say welcome Alexandra Flynn. Dr. Alexandra Flynn is an associate professor at the University of British Columbia. Her teaching and research focuses on municipal law and governance, including Indigenous municipal legal relationships. And she's been currently working on a lot of really important issues surrounding homelessness. Just yesterday, she had an incredible op-ed in the Globe about the essentialness of belongings to personhood and how the regular practice of taking belongings away from homeless persons impinges on their human dignity. Alexandra has also done extraordinary work on the constitutional status of cities and the legal personhood of land. And today she's going to be speaking to us about strong mayors legislation. I'm going to introduce everyone in turn, if I may. Eric Adams. Well, Eric Adams is the mayor of New York City. As my students know, I get one joke a day, and that was it. So thank you. Just joking. Eric Adams is our professor at the University of Alberta Faculty of Law, who publishes widely in the fields of constitutional law, legal history, human rights, and legal education. He has done incredible multidisciplinary research that engages all aspects of constitutional theory and history. And he's recently just started completing his Shirk-funded participation grant on the landscapes of injustice, which investigates the dispossession of Japanese Canadians during the Second World War. And last, but certainly not least, we have Dean Robert Leckey, who, as my co-chairs like to know, who we always hope to come because he's just a wonderful commentator, especially on one of our large subjects for today, which will be on the subject of the Notwithstanding Clause. So Dean Leckey teaches and researches in areas of family law and constitutional law and comparative law, and he's been doing incredible public-facing work on Bill 21. And his 2019 piece, which I would recommend to everyone, on advocacy and the Notwithstanding Clause, is really an important read. He has an important book on the Bill of Rights and the common law, and an absurdly lovely collection entitled After Legal Equality on Family, Sex, and Kinship. So we'll hear from our three speakers in turn for about 18 minutes and then open the floor. Thank you.
Hello, everybody. I'm so honored to be here with all of you. As Eric and I were just saying, this is such a cool panel. Like, in addition to speaking at it, I'm so excited to be listening to these incredible people. And huge thanks, of course, to Emily. When I asked Emily what I could speak about, she said, whatever, you just do your thing. So hopefully this thing is good. So I'm going to talk first about my sort of view of municipal authority, which is like this teeter-totter. This is our Canadian municipal status, essentially. And this isn't for any of you who have little kids, this isn't like the little kid teeter-totters that are really safe. This is the one that I had as a kid where the other person would get off and then I'd fall and land on a bump. It's like that kind of teeter-totter. And it's this teeter-totter that goes between the view that municipalities are a kind of government and the view that municipalities are an administrative body, that they are the instruments of a provincial government, essentially, to assign priorities. And there's a balance because the truth is Canadian municipalities are both of these things, right? But my view is that in the context of Ontario's recent legislation, we've hit a bit of a bump here, a big hard bump, and I'm going to talk to you about why. So I'm going to briefly talk about the constitutional status of municipalities. Then I'm going to outline the recent legislation that's been introduced in Ontario. And then I'm going to talk about what the implications are of this. Is this something that's kind of a continuation of the way that provinces have intervened with municipalities in the past, or is this something that's really different? Okay. So municipalities predate Confederation. As you can see from this chart, city councils were incorporated prior to the introduction of the Constitution in 1867. And with each successive adoption of a new province who joined Canada, they joined with municipalities in them. And these municipalities were our first kind of democracies, our first kinds of local governments. Now, amidst this longevity of cities existing in a way that, again, predates provincial governments or the federal government, under the Constitution, Section 92(8), responsibility for municipalities falls to provinces. Some people call this the idea that municipalities are a creature of the province. Municipal law nerds take exception to this statement, which we could talk about more. But regardless of the way that this wording exists in the Constitution itself, alongside constitutional principles such as federalism and democracy, Canadian jurisprudence over the last 2 decades in particular has given a different concept of what municipalities are and what that section 92(8) means. So the Supreme Court of Canada has been careful to note that when it interprets municipal authority, it isn't disturbing or rewriting the Constitution Act. So nobody's claiming that this section doesn't exist, but the kind of language that's been used by our courts to describe what municipalities are include the Supreme Court of Canada's statement that municipal governments are democratic institutions through which the people of a community embark upon and structure a life together. Or in Catalyst Paper, a 2012 decision of the Supreme Court of Canada, that when municipal decisions are reviewed, courts must respect the responsibility of elected representatives to serve the people who elected them and to whom they are ultimately accountable. So alongside these judicial decisions, we also have provincial legislation that for a particular time in our history brought some meaning to those words on paper that the Supreme Court of Canada said. So for example, under the City of Toronto Act, which was introduced in 2006, Section 1 of that act states that the City of Toronto exists for the purpose of providing good government with respect to matters within its jurisdiction, and City Council is a democratically elected government which is responsible and accountable. And Toronto was given fairly wide discretion under Section 8 to pass bylaws for general health and safety. And we see this kind of trend in municipal authority through provincial acts extended in other provinces as well. So I've put up some excerpts of the Vancouver Charter and the Community Charter, and Quebec as well, and very close, Alberta came very close to enacting a similar kind of expansive authority for its municipality too. So given this section of the Constitution that we have, which is saying this sort of creatures of the province idea, and provincial legislation, which is acknowledging a role for municipal governments that incorporates these kind of judicial decisions, which see municipalities as democratic governments, it begs the question, what does it mean for provincial authority? How far can provincial authority go in circumventing the democratic nature of the municipality? So in 2018, as many of you in this room know, we got an answer to this question. So that year, the province of Ontario decided to reduce the size of Toronto's City Council in the middle of an election. And a number of candidates and electors challenged this action on the basis that it violated their Section 2B rights, as well as a number of other arguments that were expressed. The case was decided in favor of the electors, in favor of these candidates, but was appealed all the way to the Supreme Court of Canada and resulted in a split 5-4 decision, which held in favor of the province of Ontario's decision. And Chief Justice Wagner and Brown, on the behalf of the majority, stated that the case didn't actually really have to do with freedom of expression. That wasn't really what the case was about, but it was about the provincial power over municipalities. And their view, which again formed the majority, was that the province had about as close as you could get to limitless power by reasons of Section 92(8). They did state that, maybe it would have been different if Bill 5, the act in question, had been introduced just right before the election had taken place, or maybe, maybe that would have led to a different decision. But there was nothing in the decision that contemplated, for example, abolishing municipal elections altogether or changing the basic rules of democracy. And there was also a split in the decision between the view of unwritten constitutional principles, with the majority stating that there would be a very narrow use of unwritten constitutional principles, only 2 avenues that we can talk about later if you're interested, whereas the dissent acknowledged the democratic nature of local governments and the importance of protecting political discourse that was fundamental to democracy. Okay, so with that very quick 101 on the constitutional authority of municipalities, we now turn to recent events in Ontario. And just by way of caveat, there's a lot of things that have happened in Ontario. So I'm kind of picking, as many of you here know, so I'm picking and choosing a few of the acts, pieces of legislation that I think are most interesting on this point. But of course, we can talk about ministerial zoning orders and other things as well, if you're interested. So I'm going to talk about 3 pieces of legislation that have been recently introduced. Okay, so the first one is Bill 23. Bill 23 was introduced, and I should mention that all of these have been have received royal assent. Okay, so these are all good law in the province of Ontario. So Bill 23 was introduced under the guise of facilitating and building affordable housing, and it changed municipal planning, development cost charges, a number of other acts. And there are many implications in this piece of legislation for municipalities, but the one that has received the most pushback from local governments has been the limits to development cost charges for the construction of affordable housing. And the Association of Municipalities of Ontario has noted that this amendment alone will cost cities approximately $5 billion in revenue, and Toronto anticipates the costs of this bill alone at $230 million. The next bill is the one that has received, I think, the most amount of outcry, at least in terms of the public view. This bill proposes additional mayoral powers. So it amends both the City of Toronto Act and the Municipal Act to enable mayors, and at this point it's just 2 mayors, so the mayor of Toronto and the mayor of Ottawa, to propose and amend certain municipal bylaws related to prescribed provincial priorities and enable council to pass those bylaws if 1/3 of members of council vote in favor. It also allows the provincial cabinet to prescribe provincial priorities, which will apply to these new mayoral bylaw powers. And we'll talk about those in a moment when we now move to Bill 3. So Bill 3 established even greater governance powers to the mayor. So under Bill 3, the mayor is now able to establish committees of council, appoint the chief administrative officer, who in the city of Toronto is the city manager, and the power to determine the city's organizational structure. It also allows the mayor to direct city staff to undertake particular kinds of research, provide advice to the mayor on city policies and programs, and to implement mayoral decisions related to powers that fall under this provincial priority designation. And the mayor also has a veto that can only be overturned by a 2/3 majority of council. So for any municipal law nerds, please feel free to raise your hand in the room, so I'm not alone. This is a huge change to how the structure of a city like the city of Toronto operates. So the city of Toronto is the 4th largest government in Canada. It is a tremendously large government that has a 50,000 person plus civil service that has been guided by city council. It has a procedural bylaw which dictates how decisions are made. So this is a radical change to how the structure and decision-making of the city will operate. Okay, so now we'll get to the TLDR. What does this actually mean? What are the actual implications? So the purported goal of these measures is to address housing, okay? And obviously housing is in a sense of crisis. So we know that there's a tremendous shortfall in the number of homes that are needed. We know that many people are unhoused, don't have access to housing, and that a lot of responsibility has fallen to municipalities for dealing with certain kinds of issues, such as homelessness. And municipal oversight over various policy areas is kind of done in 2 ways, or can be understood in 2 ways. The first is what the province tells it to do, and the other is what local citizens ask cities to do. So this chart shows how many areas of municipal responsibility are taken from its own volition. This isn't simply municipalities are not simply an arm of the provinces in this respect. And so the 2 priorities that have been outlined by the province are the construction of 1.5 million new residential units and building new infrastructure and maintaining infrastructure to support housing related to this crisis itself. Now, Toronto's particular responsibilities that relate to housing are deeply limited by its fiscal capacity. So under the City of Toronto Act, it has the ability to levy a property tax, to collect user fees, to introduce a few areas of taxation, which by and large, the city has decided are not economical for it to do based on the costs of administration. It does not have responsibility to solve the housing crisis on its own. Housing is a complex regulatory area that does require intergovernmental cooperation. That said, the city does play an important role, and all municipalities play an important role when it comes to land use planning. So the question is this act, or are these series of acts really about housing? Is that really what they're meant to do? And critics say that actually these acts undermine rather than support affordable housing, rather than support the kind of affordable housing that's mentioned in these provincial priorities. This is partly because of the development cost charges issue, that municipalities will have less revenue, which is a major factor in the ability of all of having labor, et cetera, to come and help construct affordable housing itself, but also because the measures that are actually needed to address affordable housing don't lie with the municipality at all. They lie with the province. So in particular, tenancy protection, the availability and funding of social housing, vacancy control, policies on social assistance and minimum wage. All of these efforts lie at the provincial level. And in fact, measures that have been attempted by municipalities, such as rent eviction control or inclusionary zoning measures, have been undermined by the provincial government, not supported. The second major critique that's offered is that there's no guarantee that by making these changes, that more affordable housing will actually be built. You know, at the end of the day, there needs to be people, companies, developers that are coming forward to construct these homes. And so there's issues on the for-profit side, which again is only addressing one small part of the need, mainly for middle income individuals to reside in homes. But there's all sorts of other kinds of development that are not being assisted by other regulatory measures, such as right of first refusal to allow the construction of very low income housing. And so critics say this really isn't about housing. This is about power. This is about the province asserting a level of control over municipalities in a manner that is ultimately eroding local democracy. And so I'm going to conclude with, I suppose, a few areas for conversation, almost conversations that at the moment I'm mostly having with myself, but I invite all of you to join in on, which is, what does it mean then for these, what do these acts then mean for local democracy? What do they mean for objecting to what is being done? What can be done, in other words, to come up with a different system for municipalities that can actually help not just with housing, but with you know, having communities that can flourish. So the first kind of musing is around accountability. So one thing that comes to mind here is that the province is ultimately devolving accountability through these legislative changes, not just to the municipal level, which we have seen before. There's long been areas of responsibility that have been devolved to municipalities, like social housing. The deeper concern here is that we're seeing two kinds of shifts in accountability. One is from city council to the mayor themselves. The mayor now has much more authority under the electoral system, under the decision-making structure than councillors do, which changes the way that citizens will engage with city government. But more radically is that there's been a shift in accountability from the local democracy itself to the province. The province is identifying what provincial priorities there are. They don't just have to be affordable housing under the legislation. They can be any area that the province decides is important. And so the question is, if there's these kinds of mechanisms that are introduced, what does that mean about the buck stopping with the province? If the province is the one that's pushing for certain policy areas to be a priority and for certain solutions to be provided, then do they carry the accountability with them? So that's the first musing. The second is, what does it mean to alter the democratic nature of municipalities itself? What does it mean for this teeter-totter, in other words? So a common feature of the critique of these two bills is that they are deeply undemocratic. Ottawa and Toronto have already introduced measures to not use these powers at the city council level. That can change, obviously, with a simple vote by city council. It seems to me that the local representation piece is the one that's really going to suffer. So based on a number of studies that have been done on local democracy, the councillor is the gateway into knowing how to engage with city council. Third, there's the question of the unwritten principle of democracy. Does that have any traction? We now have a shift and change at the Supreme Court of Canada in terms of who is now on the bench. Would the dissent become the majority, as we've seen in many other cases that involve municipal authority? And then there's the final musing, which is, should municipalities be responsible for housing at all? Why this view that what is the right place for municipalities in this complex area? And what are some more positive features that can be introduced at the provincial level to assist all of us and certainly municipalities into achieving more justice in this area as well? So I'm pushing for a modern day teeter-totter when it comes to municipalities. And thank you very much for your time.
Thank you very much, Emily. That was a very nice introduction. It's a real privilege to be here. It's a pleasure to rediscover in person some cherished colleagues, and there's some former students here and some other McGill alumni. So this is all very pleasant. For disorganized scholars such as myself, it can be really hard to leave town at the busy end of the winter term. So as Emily mentioned, I had declined invitations to come here in the past. Now, if they had told me that they had a guacamole and nacho bar in the afternoon, I would have been here years ago. But in any case, it's finally happening today. My aims for our time this afternoon are very modest. I'm really going to touch on four things. First, I'm just going to summarize at a very high level an argument that I developed with the co-author Eric Mendelsohn in a paper that was published a year ago in the University of Toronto Law Journal. And the kind of core contention there is that the Notwithstanding Clause, Section 33 in the Charter, doesn't stop courts from looking at the effects that a law that's protected by the Notwithstanding Clause might be having on rights, and the courts can and sometimes should issue a declaration about those effects. Beyond that, the three other things. The next one might seem a bit basic, but I'm going to draw your attention to the choices made by the legislature. We often talk about using the Notwithstanding Clause, but there's actually a number of choices such that different uses of it look quite different. And I don't think we talk about those differences enough. The third will be to talk about the implications of those legislative choices. What are the effects for the public in how a legislature has triggered the Notwithstanding Clause? And then the fourth and final thing, I'm going to link those choices to the way some scholars talk about the Notwithstanding Clause. And I would say that some of the most enthusiastic defenders of Section 33, some are political scientists, but not only, they focus on some kinds of use of the Notwithstanding Clause, I would suggest in a somewhat romantic way. And if you look at how it's actually been used lately, some of their accounts as to how wonderful it is don't line up so much with the recent practice. So the core claim really is that discussions about Section 33 need to look closely and carefully at its technical use, and that the kind of recent examples are ones that should inform us. I'll be honest, my perspective is informed by my position in Quebec, and it really is in 2019 with the passage of Bill 21, the religious symbols or secularism law, that I started spending more time thinking about the Notwithstanding Clause. It's been used again in Bill 96, the language law, a year ago. Of course, it's been used in this province in elections law. It was actually hard keeping up to date with the use around the school employees last fall. I just sort of added a footnote somewhere saying it had been used and it's been repealed already. So the Ontario people are used to some recent uses as well, but the Quebec stuff really does inform some of my thinking. Okay, so the first idea, what is the role for courts when a legislature decides that one or more of its laws is going to produce its effects, notwithstanding some charter rights? Now, a lot of people talk about the Notwithstanding Clause, and honestly, I don't think they've read it, or they haven't read it for a very long time. So honestly, if you haven't read it lately, just take a moment, look at the thing. It does not say what a lot of people think it says, honestly. There's 5 clauses. It doesn't say anything about courts. It doesn't say there's no judicial review when the thing operates. It really sort of basically says that a legislature can declare that a law shall have its effects notwithstanding one or more provisions of the charter. That's basically it. Then there's mechanics. So it lasts 5 years. It can be renewed. but it really doesn't say a lot of the things that people assume it says. And in the UTLJ paper, we argue that sort of taking that as a starting point and thinking about the kind of general role of the courts in the constitutional system, we would say, well, why would you assume that the courts, which normally have the role of interpreting the Constitution, which normally have the role of declaring the state of the law in certain contexts, why would you assume that the Notwithstanding Clause stops them having anything to say, that it kind of gags them? And so we make the claim that Section 33 is best understood as saying that, yes, a law will produce its effects, but that there may be a residual role for the courts, and that the courts should sometimes act so that, on an application by a party with evidence, they could actually have a trial and could issue a declaration explaining the impact of a particular law on charter rights. We worked through a number of the kind of objections you might have. Oh, this is hypothetical, this is moot. We would say that charter rights continue to exist in the world. And so a law that has its effects, notwithstanding the charter, is violating rights in a way that people might want to know about. And one of the things we develop in the paper, why might people want to know, or why does it matter? The Notwithstanding Clause itself, with the 5-year sunset, we think builds in the idea that the electorate has something to say here. And so there are circumstances where for the public to know the impact of a law's protection by the Notwithstanding Clause, like that's actually relevant to the public's constitutional role. And so that's the kind of core claim. We say that it's a defensible interpretation of Section 33. We draw on things like the unwritten principle of democracy, the unwritten principle of protection of minorities, and so on. We point out that the Ford decision, some people think that Ford in 1988 was like the last word on the Notwithstanding Clause, that they got it so right. Like, the first time they look at Section 33, they say everything that is to be said about it. Doesn't make a lot of sense to me. There's clearly been other charter issues where the court has come back to things. Unwritten principles were recognized in 1998. In the secession reference, the court says they have a role to play in constitutional interpretation. So the idea that an interpretation reached in 88, without any attention to those principles, the idea that it's sort of untouchable today, a minimum seems to me not very convincing. So all that's there, but our piece, if you ever look at it, we actually take Ford as the state of the law and say, even with Ford, even with the idea that to trigger the Notwithstanding Clause, you just need to pass primary legislation, you just need to name the sections, you can do it, preemptively, all that, we say the courts may still have a role to play. And we say that the courts would exercise their discretion in terms of when to do that. And courts know how to do this. Courts make declarations sometimes, and other times they say, no, we're not going to do it. We argue that it's fully consistent with the role of the courts. And we think there are other cases fairly close to it, where courts have declared the impact on rights without striking something down. The Cotter decision, where for sort of respect to the executive reasons, the court declares that Omar Cotter's rights have been violated, but does nothing more than that. To me, is an instance where courts take seriously that simply declaring the state of someone's charter rights can itself be a judicial function worth doing. There are other instances as well. But anyway, that's the claim, that courts sometimes have a valuable role to play in informing the electorate about the impact of a protected law on charter rights. And don't get me wrong, I'm fully open to the idea that a legislature has their own reasons, that the elected lawmakers say, look, we disagree with the court's judgment, we're interpreting rights differently, we're doing the balancing differently under Section 1, all that kind of stuff. But there are some cases where the public actually doesn't know what's going on, and those are the ones that are of concern to me, and we'll come back to that in a moment. But the next thing, I said it was very basic, but there are choices in how to use the Notwithstanding Clause. The verb using it sort of suggests it's one act, but you can actually decide to protect one provision of a law, you can protect an entire law, you can protect an entire statute book, as Quebec has shown us how to do in the early 80s, when in a kind of protest, it protected like every single one of its statutes from the Canadian Charter. And you can protect a clause or a law or a statute book from one provision of sections 2 and 7 to 15, or a couple of them, or all of them, what I kind of think of as the whole shebang. But it's actually quite a big difference depending how you do it. And you can do it after you've lost as a government in court, first instance, the Court of Appeal of the Supreme Court, or you can just do it preemptively. You can say, we're introducing this legislation for the very first time, and we're going to protect it from, all the charter rights we're able to derogate from. And so all those operations, the sort of cumulative effect of those choices, make quite a big difference on the impact on people's rights. And I think they also telegraph quite different things about the legislature's attitude towards fundamental rights. And that takes me, we're moving along very well here. that takes me to the third idea. What are the implications of those kinds of choices? And so sometimes, you lose at first instance as a government in a charter decision, and you come back and you reenact exactly the same law with a notwithstanding clause derogating from a specified one right in the charter. It's pretty clear what's going on there. I think the voters are perfectly well placed to judge their elected lawmakers for that use of the notwithstanding clause. But when you have something over 100 pages long, like the language law passed in Quebec a year ago, and you preemptively protect it from all the charter rights from which you can derogate, and when asked in the legislature and in press conferences and so on, where do you think the fundamental rights problem is here? And your answer is simply, we don't want to be tied up in the courts with litigation. That's actually quite a different kind of governmental response. It sends a different message. It actually kind of sends a message, I think, of contempt towards the role of the courts and the role of fundamental rights. And it certainly doesn't help people judge whether the government has made defensible trade-offs about human rights. And so it's the kind of cases where it's opaque, to loop back to the argument that courts may have a residual role. Those are the kinds of circumstances, I think, where courts may have a role to play in telling the public what is going on. And just a little, Olga will appreciate this sitting in the back there, but Quebec's Bill 21 is really interesting. And in running through peer review, the UTLJ paper, I got a sense of how specific Bill 21 is. Because a peer reviewer, presumably outside Quebec, possibly in Toronto, reading the paper says, well, no, but surely when the legislature uses the notwithstanding clause, it's conceding a violation of rights. Bill 21, one of its early clauses, states out the key principles of respecting equality of everybody, respecting freedom of religion. And then it goes on to say, don't hire anybody wearing a religious symbol. Don't promote anybody wearing a religious symbol if they have certain occupations. But the face of the law says that it's set out to protect freedom of religion and the equality of all people. So this isn't just opacity. This is actually a kind of, I think, fairly bald-faced assertion that the law is protecting fundamental rights, where it's certainly deviating from the established judicial understandings of what those rights entail. So that is a clear case, in my view, where the courts have a role to at least let the public know what's going on. So let's turn from the implications of those choices, that is the way the notwithstanding clause is used can send more or less information to the public about whose rights are actually being affected. And this leads us really to the sort of scholarly part. And the idea is that there are some scholars, what are some of the nicest justifications for how wonderful the notwithstanding clause is? It's the idea that courts may get it wrong sometimes, that elected lawmakers may have a different view about rights, that they may disagree with some of the fine balancing under Section 1, whether something's minimally impairing or not, or the proportionality stuff. And so if you're looking at that, you're thinking about a case perhaps where the court has already pronounced and where you would use the notwithstanding clause to derogate from, say, a particular right in the charter. And there's a gorgeous paradigmatic example of this. There was a Saskatchewan religious schooling case where, first instance says, oh, you want to do something in the schools and you can't because of the charter. And then they reenact the law with derogation from from freedom of religion and freedom and equality only, something like that. It's very targeted. Turns out later it's overturned, and so the problem drops away. But some of the political scientists get all jazzed up about this, and they say, see, it shows the legislature engaging with the courts and disagreeing with the courts about rights. And that's fine, but that's just a completely different enterprise from the Quebec legislature derogating from all the eligible charter rights and in passing the entire Quebec charter, and just sort of saying, we don't want to have to defend our law in court. And people who challenge us or would purport to challenge us are going against the majority will of the people. That's a very different kind of message about rights. That's not engaging. That's not disagreeing about the weighing of things under Section 1. And so, you have these debates about that Section 33. I think it's important for people to be clearer. What kinds of uses are they thinking about? What are their paradigm cases? And if you look at the recent uses, I think you've got to take seriously that the kind of mega whole shebang use has been used a couple of times in Quebec. It's been copied in Ontario, could be used elsewhere, but let's at least, if we're going to talk about it, make sure that we're kind of attached to the different ways the thing has been used. And so that is the kind of core idea of a little chapter that will be published with the things here, but that it's that the scholarship does need to take account of the sort of evolving data set. And of course, over 40 years, the thing has been used in different ways. but the recent uses by populist governments where the defense really is, the people want this. We're not concerned about the impact on individual vulnerable people. Like that's, to me, that requires a different kind of engagement than the finer disagreements about rights. I think I'll stop there, and then we can come back to anything we like to do in the discussion. But it's really a call to read Section 33, to think long and hard about the role of the courts, and not to sort of dump a privative clause into the Canadian Charter that isn't there, and then to think very carefully about the different ways legislatures use the device, and to think about the implications of those choices for the way we think about it. Thanks so much.
And I think we have some slides up for Adams, if that's okay. Thank you very much.
And I think I'll just stay seated, because then maybe in your imaginations, you'll think he could be tall. Maybe that's, I don't know. It seems like he might be, and you'll never know. Here we go. On December 15th, 2022, the Alberta Sovereignty within the United Canada Act received royal assent and became law. The law first came to public attention in Alberta when Danielle Smith introduced the concept during the leadership debate, or the leadership race, to replace Jason Kenney as head of the United Conservative Party of Alberta. As her chief strategist, Rob Anderson, and the architect of the law, explained in June when the proposal was released, I think a little constitutional crisis is a good thing. In my time, I want to speak about, one, the origins of this law, two, its proposed mechanics. And I say proposed because certain of its elements remain vague and it has never been used in practice. Three, its unconstitutional features, in my view, and conclude with some concerns about the drift of our constitutional culture. Throughout, we might ask ourselves whether Premier Smith is right, whether her vision of provincial sovereignty is about saving Canada, or whether we are entering an era of strain on the Federation that will test the Constitution's capacity to truly reconcile unity and diversity in a productive and peaceful fashion. Let me say just a little about how this act originated. And there is, of course, a much longer story about Alberta's sometimes fractious place in the Federation that I will not tell, except to say that most Canadians might be surprised to know the extent of the significance and impact of the separatist sentiment that exists at the political level in Alberta. Separatism has been rated at something between 18 and almost 30% of the public in the last few years. And where there is a political sentiment and energy behind it, there will always be a political party eager to capture it and marshal it for its purposes. Such was the case with Jason Kenney's UCP government. In order to mollify or again, generate some affiliation or affinity with this group, he called what he called the Fair Deal Panel. It would travel the province discussing the issue of the problem of Canada with Albertans. The Fair Deal Panel, which was a product of those meetings, led by a series of MLAs and people like Preston Manning and other senior members of the conservative political establishment, released this program in 2019. And just look at that final sentence from what you might have thought would be a sort of anodyne government report. No, it's a call to arms that the rest of Canada is attempting to eliminate our way of life. Those are the stakes that some Albertans feel is on the table. Similarly, the Buffalo Declaration, the product of 4 conservative-based MPs in Alberta, released a statement saying that Alberta is on the cusp of separation. Unless the Federation changes, Alberta will seek to separate. That's from 4 sitting members of Parliament. And finally, Jason Kenney's equalization referendum in 2021, one of the recommendations of that Fair Deal panel was Albertans hate equalization so much. Let's have a referendum to see if we should eliminate it from the Constitution. 62% of Albertans said that we should. And I lost like 6 months of my life to doing media interviews on this topic. I think sometimes we think about the rough and tumble of the political situation as being immune from the more sober realities of the judicial enterprise. And I'm sad to say in Alberta, that's not the case. Look at the majority judgment in the Reference Impact Assessment Act decided in the midst of these political dynamics in May of 2022. Here are quotes, I won't read them all, but you can look at them from the majority judgment of 3 with a concurrence in a 4-1 decision of the Alberta Court of Appeal. This is all from an opinion which included the then Chief Justice of the Alberta Court of Appeal. And I'll just pause for a moment as you take in those quotes. What struck me on first reading, and I hope disturbs you now, is the underlying violence of the imagery that the court is peddling in. This, in my view, is unacceptable, Judge Kraft, in what should be a defensible position that the Parliament of Canada had overreached its jurisdictional authority in a division of powers case should always be discussed with all degree of seriousness, but also with prudence and caution and respect for all levels of government. And it's no surprise that this opinion, including several direct quotes from it, have emerged in the political campaign literature of the Conservative Party, have been read out on the floor of the Legislative Assembly as evidence of the necessity for the Alberta Sovereignty Act. The most direct antecedent of the Alberta Sovereignty Act is something called the Alberta Sovereignty Act, which was a proposal of the Free Alberta strategy, which emerged from the minds of Rob Anderson, again, remember Danielle Smith, chief campaign strategist, and now the chief of her executive office, and Barry Cooper, a political scientist at the University of Calgary. And in the Free Alberta strategy, which contains a number of proposals, an Alberta-based pension, a removal of equalization, Alberta police force, was the centerpiece, the Alberta Sovereignty Act. And the Alberta Sovereignty Act had as its centerpiece the idea that Alberta had the jurisdiction to refuse to comply with federal laws and to refuse to comply with the decisions of federal courts. They, as the proposal gravitated from the Free Alberta strategy into the leadership campaign plank of Ms. Smith, it kind of wavered on the court piece. It was the trial floated whether Albertans were ready for a full strategy of refusing the to follow the rulings of courts. Ultimately, that was dropped in the final proposal that hit the floor of the legislature. But in Hansard, Ms. Smith acknowledges that the Free Alberta strategy is the direct inspiration for the Alberta Sovereignty Act. In a National Post op-ed, Professor Cooper explains the genesis of the Free Alberta strategy as being unconstitutional on purpose so that we can change the structure of the Canadian Federation through political power. In the Hansard debates leading up to the passage of this act in December of 2022, it was Bill 1 in the new legislative session shortly after Ms. Smith was sworn in as premier. There are a number of metaphors used to describe the Alberta Sovereignty Act, I will say, many of them, again, adopting a kind of militaristic imagery. This idea that Alberta was under attack was a repeated phraseology, and that the Alberta Sovereignty Act would be a kind of shield in that attack, but also a sword or a tool or a club or a fist to respond. This a comment by Jason Steffen in the legislature gives you some sense of, well, who is doing the attacking? Well, it's the NDP Trudeau Axis government is the quote from that MLA. And if that was too subtle a reference for you, it was followed up by another MLA who indicated quite clearly that the direct analogy was to the Nazi regime, that the provincial NDP government should be renamed the National Socialistic Party of Canada, and that the UCP in this regard were functioning as a kind of Winston Churchill to stop the appeasement against the Nazi forces that again were ready to attack Alberta, or in the language of the Premier, Alberta's enemies. In the final moments before the act was voted on in the Legislative Assembly, Ms. Smith offered this vision of Canada, and I'll let you read it. So this, I think, is relevant to the constitutional view of what the Sovereignty Act is, and the constitutional theory from which it emerges is that Canada is not a confederation, it's not a pluralistic state defined by federalism, but rather a federation of independent sovereign states. What time I came home from looking after my kids, I came home, I left my kids alone. They were old enough to be left alone, by the way, in this story, let's say. And I came home and my son said, "We didn't break anything." And I said, "I would feel more comfortable if that wasn't the first thing you said when I walked in." So here's section 2 of the Alberta Sovereignty Act. I might have wondered if this was implied when we enacted laws, but much like my son protesting that nothing was broken, it makes me nervous right off the bat. But anyway, in case this helps sway your opinion, the Alberta Sovereignty Act is of the view that it's not unconstitutional. Here's how it works. And this is a bit technical. I'll go quickly. I don't know how much time we have. The Legislative Assembly will pass a motion that the federal government has done something through a law, a program, or an anticipated law or program that is unconstitutional or harmful to Alberta. How is harmful defined? Well, harmful is defined as something that's obviously distinct from unconstitutional. Therefore, harmful is constitutional, but interferes, note that language, with Alberta jurisdiction, or interferes with Alberta charter rights, the charter rights of Alberta citizens. Maybe the language is even broader than that. I think it's affects Alberta's jurisdiction could be defined as harmful. Well, what happens if the Legislative Assembly is of such a view? Well, then it will give the executive branch the measures that it may then enforce. And those measures include ordering what's called provincial entities to do something. That's a bit vague what those things might be, but I think it's clear that the contemplation here is that those provincial entities might refuse to follow, enforce, comply with, maybe even obstruct the operation of federal law, including, obviously, constitutional federal law. Provincial entities and their members must comply with those provincial orders, even those provincial orders that counsel individuals to defy laws of the Parliament of Canada. What are provincial entities? Well, they're provincial commissions and tribunals, universities, colleges, municipalities, things receiving government grants like daycare centers, arts organizations. No provincial entity has yet received such an order because the act has yet to be used for these purposes. So what are the constitutional issues? Well, one is the validity of the act itself. So clearly, provinces have jurisdiction to enact laws in relation to their provincial entities. Those fall within provincial jurisdiction. But does that jurisdiction extend to an order to not comply with the laws of Canada? Does that fall within Section 92 powers? I think that's a question to ask. What is the pith and substance of this legislation, if not to fight the Nazis? I'm not quite sure entirely what is the provincial argument about its pith and substance. What about the separation of powers? Can legislatures opine on the constitutionality of the laws of the other level of government, and more importantly, give legal effect to those orders or those opinions? That is, to direct their own entities to now take steps as a consequence of those findings? Or is that an exclusive function of our judicial system, our independent courts? Well, we know a little, I think, about the importance of the separation of powers from some recent Supreme Court of Canada case. It's an essential feature of our Constitution, the distinctions between the executive, judicial, and legislative branches. That, I think, will be put to the test if and when this law is challenged. And the Supreme Court of Canada has endorsed the view that legislatures cannot aggregate to themselves the power to define the ambit of their own constitutional authority. That's the exclusive domain of courts, properly so. A recent decision of Justice Gramont in the federal courts, perhaps thinking somewhat of the Sovereignty Act, but on an entirely different issue, says legislatures cannot regard the other level of government as passing unconstitutional laws on their own initiative. If they are of the view that laws are unconstitutional at the other level of government, there is a clear and acceptable constitutional path. Challenge the validity or constitutionality of those laws through the judicial process. And the reference power gives them direct access to their own courts of appeal. I'll conclude here. For the moment, this act sits in what I'm going to call the unconstitutional closet. Maybe the Legislative Assembly, maybe the government has no intention of using it. But if so, and if the argument is that without use it can never be constitutionally challenged, then there it sits, corroding core and important features of our constitutional norms. I would have thought that in the case of an egregious act of unconstitutionality, challenging one of the fundamental precepts of our federal arrangements, that it's based on fundamental mutual respect of both levels of government. Such an act, even without use, active use, has to be engaged by the courts. Thank you very much.
Can I just say I feel wholly vindicated for pushing to break the rules, the 26-year stretch to invite these three. Those were extraordinarily rich papers. We just have a few minutes for questions. We have so much on the table, something like the limits or questions about the dialogue metaphor between legislatures and the courts. We have maybe a large question here about the limits of institutional thinking in the first place, deep questions about where substantive politics fit within this terrain. We've learned that the nature of the example or the grain of the analysis through these papers certainly matters. And we have a big question here about the role of the relations of the courts vis-a-vis the political literacy of the electorate. So we have a lot here. So we can either speak to that, or you've been sitting for a while, so maybe there's something out there on these provocative papers that you'd like to ask about. Right here. And would you mind introducing yourself first, please?
I have thank you. I have a question. I have so many questions. It's a fascinating
Yeah.
panel. There's so much, but I'm going to make a choice. With respect to Notwithstanding and Dean Leckey, I know that this debate, there have certainly been academics from Quebec, and in fact, I'm hosting one, a debate at the DOJ, who articulates the view that the use of the Notwithstanding Clause, especially in Quebec, because of the unique context of Quebec, its unique culture, I know you've heard this argument, so I'm looking forward to your remarks, has special legitimacy, especially in light of the fact that, of course, Quebec never signed the 1982 Act at all, remains outside to this day in respect of that, and that's a legitimate use by Quebec to defend its distinct society, and it has to be understood from the perspective of the unique, distinct aspect of Quebec, and that is reflected in Bill 21 and also the defense of the recent changes to the language laws there. How do you answer that? How do you speak to that, given, of course, I take it you live in Quebec and you have a particular sensitivity to it. I know you've heard the argument before, and I'm anxious to hear your rebuttal or your answer to it. Thanks.
Yeah, I mean, we touch on it. Thank you for that. We touch on it in the paper. I mean, it's there. I mean, if you think that you as the elected government have particular legitimacy using the thing, why are you so anxious about the courts telling your voters like the impact of your use of it? Like, be proud of it. Like, you show up in court and you tell the court why you've done it and what you've done. And like, I don't actually see a direct conflict. Like, I don't see why, like, if the government is so confident that it's made a good decision, why would it be so anxious about having courts letting people know what it's done? So the sort of opacity, I find it the sort of mismatch between the sort of opacity and even the sort of inaccuracy of sort of saying like, we're respecting charter rights. And then if you're so proud of what you're doing in defense of the collective interest. So you got to acknowledge that Quebec specificity, but for me, it doesn't actually directly lead to an objection to the courts having a complementary role to play, acknowledging you can use it, the law will have its effects, the voters will judge you in 3 or 4 years, but why shouldn't they know? It's amazing, all these government lawyers just sitting, listening to papers all day long. I'm totally impressed.
David, did you have a question?
If Robert is right, the Constitution is a deliberative document. Section 33 is built in such a way as to allow citizens to engage and of course governments in important constitutional questions. Why is it then that the provincial government can't take a stand vis-a-vis the other level of government and in fact express outrage? The Supreme Court of Canada had an opportunity to read in the principle of federal loyalty, right? And rejected that idea and said, well, we're built on conflict, right? With two levels of government at war with each other, although they didn't use the language of any violent language. But it seems to me that a subnational unit has within its ambit authority to express opposition, to express outrage, to take steps. Maybe this will go too far. We'll see how it goes. I think the Sovereignty Act is more bark than bite. But it seems to me that you're not building in that deliberative dimension into your pitch.
Thanks for that question, David. And just so the rest of the room knows, it's always wonderful when your supervisor 20 years after you defend your PhD steps up and continues to ask you tough questions. What a thrill for me. I think I draw a distinction between the idea that and I fully concede, of course, a legislature can express its views through motions, through public pronouncements, through press releases. I have absolutely no objection at all to the Alberta Legislative Assembly or the executive branch of the Alberta government saying, we don't like that federal law. We think that federal law is unconstitutional. There should be nothing unconstitutional about a legislative assembly expressing its views
And when
about the other
laun-
level of government.
When the government launches litigation, it's saying the same thing.
Correct.
We think that.
So I don't think there is a requirement of federal or loyalty to the federal system, but I do think there is a necessity in federalism of mutual respect. And so what that means is that, and the distinction here in the Alberta Sovereignty Act is not that it allows the Alberta government to express an opinion, which of course it didn't even act to do, is that the opinions that it expresses go on to take legal effect. And that to me is the line that gets crossed, because what is now a citizen to do in the face of such a conflicting set of orders, and having set up a kind of a parallel interpretive branch with legal effect, I think you run the risk of eroding the independence and also the respect for the judicial branch in a way that could be ultimately corrosive. So I don't have a problem with provinces saying we don't like the federal government. It's what they do next.
Hi, Gerard Kennedy, University of Manitoba. Thank you all very much for your presentations. I could ask questions of all of you. I have to only ask one, so I'm going to ask it to Eric. That was a great presentation. I really enjoyed your history in building, in a particularly colorful manner, how we got here and some of the problematic statements made in the legislature. But I'm wondering how you respond to the argument that's been made that, well, how this act came about indicates a lack of seriousness and maturity on behalf of the government. At the end of the day, it authorizes some sort of process that you probably don't need legislation to do anyways, to simply decline to enforce certain law as a matter of priority in the way that BC has done with certain drug laws, or Quebec did in the 80s with abortion laws. And that, is it your view that the circumstances in which it was introduced changed the pith and substance of the law? Or do you think it actually goes beyond this discretionary decline to enforce what we don't think is a priority?
Well, I think as a matter of law, we know that what the government says on the floor of the Legislative Assembly should matter to the pith and substance. So, I mean, I don't regard the statements in the Legislative Assembly as displaying a lack of seriousness. They're talking about Nazis. That's pretty serious. So, you know, I think we have to take them at their word that this is the intention and that this is the concept of the bill that they're putting forward, and it's being voted on that basis. That's democracy. So I don't think they get to say whatever they want on the Legislative Assembly and say, oh, but don't worry about any of that. That's not the way the pith and substance analysis works, and nor should it. And secondly, you know, isn't it always the case that a province can refuse to enforce federal laws? I don't know about that. I mean, I'm not sure the Federation works entirely on that basis, first of all. And the Federation, to also succeed, must have a certain degree of flexibility and discretion. But what's being displayed here is outright hostility to the idea of mutual respect and compliance in a federal state of affairs. And that, I think, changes, as it should, the constitutional analysis of the law before us. And you know, the BC example, BC didn't prosecute drugs. That gets brought up a lot by defenders of the Alberta Sovereignty Act. I mean, the most latest version of that agreement is literally an agreement that is prescribed in legislation. So it's not quite an analogous scenario in my view.
There's 1 minute left, and I'm just going to take the chair's prerogative to ask one question that I must. Well, I have many questions that I must ask, but it's for you, Robert. And I'm wondering, I'm thinking about Deb Parks and Sonia Lawrence's using this term of destabilization, thinking about charter rights. And I'm thinking that the tension will just be so high. I really love the way you put it, that the court should opine on something violating a right in an unjustifiable way. But it seems that also like that pushes tension to the populace to see in full clear light the impact of the law, but it's doing something, and maybe this is why the courts shirk from this responsibility. It's doing something to the court's own authority in the right space, right? To say, like Cotter was a challenging example. The court did nothing in the face of this terrible rights violation, other than issue something like a declaration. So is there like a tension that will reflect back on the court's own status and role that gets set up on your vision here?
Oh, for sure. I mean, we say in the paper, like, this might not be comfortable for judges, but we don't actually think that like judicial comfort is like the guiding
Right.
principle. I mean, they do other things they don't need to do. They rule on moot cases, like, so that they do make decisions that at times it's appropriate to declare the law, even though like it's not essential that they do it. I've also been asked whether like the backlash would be such that they shouldn't do it. I don't know what the backlash would be, but like there is polling where Quebecers are like, I support Bill 21, but if it discriminated, I wouldn't support it.
Right.
So there is something where there's something powerful about being told by a court that fundamental rights are being infringed. And at the moment, it's just sort of diffuse. And so, you know, should the legislature be spared having that kind of declared and put out there? If it's got its own justifications, I don't think it should be ashamed or afraid. But I mean, Bill 21 is papered with slightly cowardly signs, right? There's a grandfather clause, so no school teachers were fired the day it was passed. It's just supposed to stop other people being hired or people transferred from school districts or promoted. So like, again, if you took seriously getting religion out of the schools, like you would fire all of them yesterday. You would say like, our kids are at risk, you got to get rid of them. They're not willing to do that. And so, you know, do the courts kind of collaborate, or do they say like, voters, look, you're grown-ups, but just so you know, like this law is violating rights in an unjustifiable way. And so the moment the 5 years lapse, unless this is renewed, like this thing's going to be struck down. But I don't think judges are going to like say, oh, I would love to do this. But we invite judges to think really hard that if they say elsewhere they're the guardians of the Constitution, they say that in Hunter and Southam and stuff, like, you know, connect the dots that maybe they do have a duty. And if it's a duty, then the question of whether like it feels fun to them is not the final question they would ask themselves.
Okay, please join me in thanking this excellent.